Well, Jack, I really appreciate the kind words, but you left a little bit out of that story, at least what you, Jack was writing a book, and he sent me a portion that he had written that he was going to put in the book. And the part that kind of sent a shiver down my spine was that he told me that the first time that he came in, and after I was done, he had said I had chewed a part of his anatomy off, that he went home and said he put me on that list that someday you'll get even with them. Someday you will get him back. And that kind of bothered me to know that I was on that list. But Jack told me he went and thought about it. And then he went looking into it. And Jack and I have become good friends since then. And I can tell you in the room that we were in when they were working on SB 281, and I think I was the only Republican in that room. There was the governor's lawyers were in the corner. 5 or 6 other leading legislators were around there. Jack McCauley was to my left. And I think you had 1 or 2, another state trooper who I think had a higher rank than you to your left. Is that correct? Okay, there was another person there. And I turned and I asked Jack one question, that they were trying to say that these firearms were more dangerous because of items on them that all of us would say were simply aesthetics. You know, it's black, it's a gun, it must be more dangerous. And when I turned to ask Jack a question, the attorney in the corner said, "You can't answer that." And I looked at her and said, "How dare you suppress his First Amendment rights when he's sent here to answer questions so we can protect your Second Amendment?" I went again and I tried to ask him a question. And she said, I'm ordering him not to say. I said, he doesn't work for you. He doesn't work for the Attorney General's office. He works for the state police. And Jack wasn't going to talk because he knew right then and there, and I knew it. And I was so mad. I was apoplectic. I stood up. I'm yelling. Jack will tell you. And I really didn't know what to say. And it kind of came out wrong. But I just said, I'm telling. And I didn't know who I was going to tell. But I was letting them know. We were upset about this. So all I remember is the meeting broke up while I was still standing up yelling at people about telling the state police officer who was sent there to answer questions to make sure everybody understood what we were doing. And when he was going to answer a question, he was told, "You may not answer the questions. We were going to go ahead with this bill no matter what." And I can tell you that I sat many a times in the sessions in the back room, and we would want to do something on the firearm they didn't know anything about. And somebody would say, "Well, that thing on the end, that flash suppressor, that's so people can hide in the woods and shoot at night and nobody will know where they're at, right?" No. Keeps fire from coming out the end of the barrel so you can see your target downrange. Keeps you from having any kind of a fire. And some of these are just so the gases will keep the end of the firearm from going too far one way or the other as you fire it. So they didn't know the difference between a flash suppressor or any other part of the firearm. So when we're talking about that, the chairman says, "Well, can't you just unscrew that, keep it in your pocket, and put it on when you get out there?" I said, "Well, Mr. Chairman, it'd be really a problem for me to go tell people we've made it outlawed for no real reason, but you want us to be able to unscrew it, carry it in our pocket, then break the law, put it on, use it, and then take it back off. Why are we doing this?" He says, "Martin O'Malley has to have a bill. Martin wants something, so we got to give him something." I said, "Well, we gave him the grenade launchers. What else do you want?" So, we agreed there'd be no grenade launchers on the AR-15s. But Jack was there. He saw in the back room the way this bill was put together. And what most people don't know around the state is the legislature came to an agreement. Democrats and Republicans in the back room on a Friday night, we're not going to put out this Firearms Safety Act. SB 281 was dead. We said we're going to send it to summer study. We're going to take the Handgun Roster Review Board and turn it into what they were using the term, an Assault Weapons Review Board. So we were going to change the Handgun Roster Review Board to look at this and have them come back and give us recommendations. We all went home. It's done. We were celebrating victory. Next morning when we come in, Saturday morning, we're told there's the bill. They're going to present it. Martin O'Malley's attorneys stayed up all night. They put out the bill that you have here today, which was people who know nothing about firearms, and that's what they started to vote on. We screamed and yelled, wait a minute, the legislature sets policy. We do this, not an executive. And that's an example of putting party ahead of principle. The principle is you have a separation of powers, and the legislature is supposed to set policy. We're supposed to do this, and the executive then enforces it. But we as Republicans are just as guilty as Democrats. When we have a governor in office, we put our party ahead of our principle. And that's why a lot of people today are saying, well, why is it that we have our organizational leaders saying, well, don't put in any legislation. Let's not put something on the governor's desk that's going to create a problem. I was down at the 282 rally this Tuesday, and a gentleman came up, stood behind me, and showed me that he had a simple request for a bill to extend to 5 years the permits to carry in Maryland. Seems like a very simple request, shouldn't be real controversial, that you should be able to put in. Then he showed me the letter he got back from Nick Kipke, the Republican leader, that said, we've been told by MSI, NRA, the Associated Gun Clubs, not to submit any legislation. And I said, why? What's that about? He goes, they just said that they're not going to submit any of these gun rules, that we shouldn't put them before the governor. This is a case of putting the party above principle. It's a perfectly reasonable bill. We should try just as hard when we have a Republican in office as we do when we have a Democrat in office. Doesn't matter who's in there. You all swear an oath when you're elected to uphold the Constitution. And it doesn't matter who you're upholding the Constitution against. And so those are the things that we need to make sure today are being upheld. Now, there's a bigger problem, and the reason I came here today and that we're going to talk about is what's going on around the state. Right now, we have state troopers showing up in plain clothes on people's doors, knocking and saying, without a warrant, you have to turn over your firearms. I'm here because Mr. Norton had this happen to him. State troopers came, knocked on his door. He asked if they had a warrant. They said no, and they're going to ask him to turn over his firearms. He hasn't done anything wrong. Nothing has changed for the last 10 or 15 years. But here's what's going on. In Maryland, currently, if you're a convicted child sex offender, you're treated better than a law-abiding citizen simply trying to exercise your Second Amendment rights. I wrote an article in the Maryland Bar Journal in September and October, and it explained why that is. Here's what's going on. Remember a few years, everybody was upset because we had to take about 80 sex offenders off the sex offender list, and they said, why are they taking those people off that list? It's because under federal law, our Constitution is interpreted as saying you can't have ex post facto laws. That means if any of you had eggs for breakfast last Monday, they can't pass a law today that says it's illegal to eat eggs and hold you accountable for what you ate last Monday. But that's what we're doing currently with our gun laws in Maryland. What happens is the federal government says, yes, we can't put you in jail for eating those eggs, but we can put you on a list as an egg eater because that's just an additional burden. It's not an additional punishment. And that's what they did with the sex offenders. Somebody 20 years ago had done something, and they said you can either stand trial or accept this punishment. And a third-degree sex offense is you're on the beach, and a pretty girl walks by, and you smack her in the butt. That's a sex offense. And so back then, somebody said, you know what, I don't want to go to trial. I'm sorry, it'll never happen again. And they make an agreement with the state's attorney. Some of them may have been very heinous acts that should be punished, and they should be in jail. But they could be something where you make an agreement. At the time, nobody says you're going to spend the rest of your life on a sex offender list. Under the federal government, that's okay. They can put you on that list because the federal government says as long as you're not being punished, you're just being burdened. That's okay. Maryland's High Court decided that our Constitution says no additional punishment, no additional burden. So they had to let all the sex offenders off. Now today, to this day, there's an Attorney General opinion from Joe Curran, the father-in-law of Martin O'Malley, who said that it's okay to use an ex post facto application, look back in the past for new laws that are passed today. So 20 years ago, you may have had a charge in Pennsylvania for phone harassment. It may have been 6 months. Now, either Pennsylvania or Maryland makes that a 2-year charge. And they say, well, if you had a charge that when you were a juvenile would have been an adult charge, we can keep you from being able to own firearms. So they'll look back retroactively now. And so in the interim, I get a call from a man who shoots movies. He's down in Washington, D.C. He says 30-some years ago, he had a charge. He married the woman. He and his wife had a fight. She took his car or something like that. But there was nothing. They've been married, never had a problem. 30 years passes. He goes to apply. He has a federal license for machine gun. He has the federal license for the suppressors. He shoots movies and uses blanks. He's told now he can't own a firearm. He can't have a blank pistol on his movie set. It's going to put him out of business because Maryland has used an ex post facto application of SB 281, the Firearm Safety Act, and they're going back. This is unconstitutional. It should not be happening, and it's happening around the state. The governor's office called me in to talk with them about policy. I met with the governor's chief of staff a couple weeks back, and I explained there's a problem. There's going to be a big problem when a plainclothes person shows up on somebody's steps without a warrant and says, give me all your firearms. Eventually, we're going to have a problem. Put the state troopers in their uniforms, get warrants, but we're going to have a problem unless somebody takes care of this. And it's happening all over the state where the state police are showing up, knocking on the doors, and it's because of this ex post facto application, which is an unconstitutional application of this law. So there's this additional burden where they're saying, we can take your firearms, you're not going to jail, but we're going to do this. Our high court has already said with criminal sex offenders, we won't apply that. Yet we're applying it to law-abiding citizens. So that's something everybody should be aware of. I'm going to end up taking this to court and challenging it. It should not be happening to law-abiding citizens. And some of the other things that are going on, we paid $2.5 million recently under SB 281, do a study. The study comes back, it's supposed to be out the 31st of December. I asked to see the study. I'm told the study isn't there. I called the state policeman who's assigned all my questions because I wasn't allowed to just talk to any state trooper. They assigned one to me when I was in the legislature because of things like with Jack. There was actually somebody who did your job before you. We asked one day and they quit. They were done. They didn't come back to the legislature, but Jack had more intestinal fortitude. He kept coming back. But they had somebody assigned to us, and so I called this person, and they were kind enough to get me a copy of the report. And it's one paragraph. In that paragraph, it says that during the 2 years since SB 281, there were 17 illegal transfers of firearms. I thought, well, that's a lot because actually we don't really charge the people, and even if they are charged, they rarely go through with it if they prosecute them for 17 of them. And to look into it, it turns out it's one transfer of 17 firearms from a Maryland federal firearms license holder, an FFL, to a Pennsylvania FFL. So he took the 17 firearms to Pennsylvania, and there's a man in Pennsylvania who says, I'm a Pennsylvania resident. I'd like to get those 17 firearms. He gets them, but he's really a Maryland resident. So somebody lied in Pennsylvania about firearms they got in Pennsylvania, and the Maryland State Police list that on the statistical report that we paid $2.5 million for as 17 illegal transfers in Maryland during that time. It certainly wasn't. And I sat with the governor and I said to the governor's staff, you need to make sure the state police stop misleading on information like this because it makes it harder for the legislators to be able to make a decision when they sit down. It's kind of like Vinnie DeMarco yelling and screaming about, oh my goodness, we got to stop all of these transfers that are straw purchases. Well, I asked him to stop the hearing. Mr. DeMarco, can you name a single straw purchase in the last 5 years? No. Can you name one in 10 years? No. So there's not a single straw purchase, but if you see the driver behind the legislation are people yelling and screaming about we've got to get rid of those illegal purchases or straw purchases of assault weapons, as they refer to them. Now, a lot of you, I guess, heard yesterday, we got the decision came down, might have been yesterday or the day before, it's all a blur, the Colby decision. Is everybody aware what that was? In Maryland, to find out whether or not the Firearms Safety Act is constitutional in that they can ban the AR-15. What happened is the court found, the appellate court, the Fourth Circuit, that in fact the AR-15 is not inherently dangerous. They used a lesser scrutiny to look at whether or not the firearm could be banned. They're supposed to use the highest level of scrutiny as to whether or not you can infringe upon a constitutional right. And actually, I kind of differ from that. I have a problem with that because if you look at the Constitution, Second Amendment just says, shall not infringe. Doesn't say there's a dimmer switch. You can infringe this much, you can infringe that much, depending on how much of a governmental purpose is being enforced. The Constitution doesn't do that. The courts have done that, but it just says you shall not infringe upon that Second Amendment right. So what's going to happen now is they're going to kick it back. Understand, we sold more AR-15s than Ford F-150 trucks. So they have to say it's an inherently dangerous firearm, that it is unusually dangerous. It can't be the most common firearm out there and somehow be unusually dangerous. You've seen Frosch, the Attorney General, was on TV news the other night. He said two things. This is the most preferred firearm, for, he said weapon, for mass murders. He's wrong. There's no statistics to show that. And in fact, when we asked, can you show us a single death in Maryland by a legally owned one, they couldn't. And they, in fact, couldn't show us that they were used against police officers. So that is a false narrative. And the second thing he said is it has no legitimate purpose in home defense. Absolutely false. If I take a .45 caliber or a .44 Magnum or a .357 Magnum handgun, you got to be more proficient to be able to hit your target. So if your wife is at home and you're not and the man comes through the door, you got to be more proficient. And secondly, if she misses, it's going to go through the wall. An AR-15 won't necessarily do that. An AR-15 is actually meant to wound, because in battle, you wanted to wound that opponent, so 2 or 3 people were necessary to drag them off the field. To drag them off the field of battle so that you'd have less out there. So it wasn't necessarily made like a .45 was to stop you in a close combat, in a handgun. So he's absolutely wrong when he says that it has no legitimate purpose. The idea with the magazines, they did the same thing. You can't be a high-capacity magazine if it's the standard capacity that comes with the firearm. If the firearm you're purchasing has a magazine that has 15 or 17 or 20 rounds, that's standard. If you go out and buy another magazine that has a big barrel under it and it holds 100 rounds or 50, that could be a high capacity. But what happens is the narrative becomes any magazine over 10 rounds is going to be high capacity. And Jack McCauley came up here and told you exactly why in Maryland we have this rule that says you can't manufacture or sell the 10-round capacity magazine, but you can still own them. You can still bring them into the state. You can still have them here because the speaker thought they were disposable. Like in the movies, you drop them, you walk away. Well, that's not the case, and I wasn't going to tell them they have a spring in them. So the idea that what we're being told right now is that these are inherently dangerous, that we have to look out for you, is just absolutely a false narrative. You have a constitutional right, and as I stood on the floor of the Maryland House of Delegates, and I said, it doesn't matter what any executive says, it doesn't matter what any legislature says, and it doesn't matter what any court says. It's a God-given right. And when I said that, I got giggles in the audience, And I said, no, it is a God-given right. It comes by virtue of our being born to have the right to self-defense. And so that is a right that none of them can infringe upon. And if government attempts to infringe upon it, I'll stand side by side with my constituents and will nullify it. It means nothing what they attempt to do to take away that right. That is what the Second Amendment does. It doesn't grant us a right. It prohibits the government from infringing upon a God-given right that we all possess.